And it has been an especially important way of staying connected during this year of unprecedented everything. So just as we all went remote, and at the same time as new regulations required that we were tighter than ever as a community about who we are, what we stand for, and what we're going to do about it. In June, during our last set of community conversations, we talked about the 2020 Department of Education's new Title IX regulations that were to be implemented by August 14th. We met that deadline, and Valerie and Mags will tell you shortly about what's in place. More importantly, however, they want to also invite a conversation about what's next. We often talk about being in compliance with regulations as being the floor, the minimum of what we should do. But we should also raise our sights to what we want our gender equity work to look like going forward and how it might tie to other work that promotes justice and equity at UW. Also, in the name of setting context, I want to remark on where we are in time. Back in June, when we last gathered, the violent deaths of George Floyd and Breonna Taylor and others led to a rising crescendo of activism and action. That energy stays front and center now, here in October, in our final week before the November 3rd general election. And as we move into our 9th month of the COVID-19 pandemic, and as we watch unprecedented wildfires burn huge swaths of the West. The election shapes a great deal of the future, not least of which are the Title IX regulations, which are the subject of today's conversation, and are generated by Donald Trump and Betsy DeVos's Department of Education. It seems like now is a great time to reaffirm our goals to challenge oppression, violence, hate, and to come together to examine and reinvent our systems and structures so that they can better serve all genders, all races, all identities. Let me introduce our two speakers for today. Valerie Richardson is the UW's Title IX coordinator, and Mags Alex is the UW's Deputy Title IX coordinator.
Thank you, Glenna, for that introduction and those important words about our world and our work. As we do our work to prevent and address sexual assault, sexual harassment, and other forms of sex and gender-based discrimination, we do so with key values as our guide. I want to start by articulating the guiding values that have informed much of our work and that will continue to help us move forward with integrity in this moment and beyond. Trying to get to the next slide. There we go. First, a word about the term survivor. Words are important different things to different people. Not everyone who has experienced harassment or sexual violence will choose the same language to describe what they have experienced. We use the term survivor and are also aware of the limitation of language. With that said, survivor choice is one of our guiding values. We believe it is important to give a survivor agency in determining who knows about their experience and what actions, if any, are taken in response to what they've experienced. Taking away that choice and compelling certain action can result in additional harm, trauma, and even retaliation. So we center survivor choice when considering how to address sexual harassment and other sexual misconduct. Next, community responsibility. At the same time that we center survivor choice, we also have a responsibility to the greater community to assess for potential harm to others. If a survivor does not want to make a formal complaint and we are aware of a pattern of behavior that could harm others, we must assess and engage on how to reconcile that tension between survivor choice and community harm. In addition, we have a responsibility to get together as a community to work upstream to prevent harm from happening in the first place. Next, I'll touch on equity. Title IX is a federal gender equity law. Our charge is to ensure that individuals of all genders have equitable access to education and work activities, that policies and procedures are equitable for all involved, and that due process is embedded in our formal procedures. And then the final value I'll touch on today is our commitment to work beyond compliance. This value is one that we have embraced very intentionally over these past months, and that is a part of a broader path to institutional courage. As described by Jennifer Fried and her center in Oregon, institutional courage is a commitment to seek the truth and engage in moral action despite unpleasantness, risk, and short-term cost. It's a pledge to protect and care for those who depend on the institution. It's a compass oriented to the common good of individuals, institutions, and the world, and a force that transforms institutions into more equitable, accountable, and effective places for everyone.
Before we proceed, we want to share a few additional words about equity. In our gender equity work, and particularly in complying with federal and state law, we are cognizant of differences between equality and equity. If you view these two images, you'll see that equality, where each individual gets one box, does not result in everyone being able to watch the game. The fence and the hill are sloped, which is a metaphor for the inequity that individuals experience because of systemic inequality and oppression, which are pervasive in our culture and society. In the context of gender equity, the boxes represent different supports, services, and policies. Based on individual characteristics and experiences, people need different things to be able to access their academic or employment environments.
In the context of our values, with equity paramount, we're committed to moving forward with the institutional courage I referenced a moment ago. What that means is that we not only comply with our civil rights laws, but we also move beyond compliance in both our policies and practices. That means committing ourselves to educating every member of our community on these issues, from first-year students to senior administrators. It means taking great care in developing our policies and practices related to disclosures, and responding well when we learn that someone has experienced sexual violence, harassment, or other forms of discrimination. It means cherishing truth, listening, hearing, and allowing folks' lived experiences to inform our work. And it means analyzing and understanding our campus climate survey data as one way to better understand what folks are experiencing in our communities. It means evaluating what we do and making improvements. And it means working towards greater transparency, both with our data and with our policies and practices. These are the elements of institutional courage we will be leaning into with renewed vigor this year. And we invite you to join us on this journey. So now let's get into the specifics of the 2020 federal regulations. As you're likely aware, these new rules from the US Department of Education are controversial. Many of us who work in the realm of gender equity, civil rights investigations, and prevention of sexual violence and harassment don't believe that they will result in more equity or due process. We already have those elements enmeshed in our UW systems. Instead, we worry that these new rules make our processes more burdensome and confusing, and that they will further deter folks from coming forward with formal complaints. And finally, these new rules are resource intensive, and we believe university funds could be better utilized for the benefit of our students and broader UW community. That said, with our UW values as our guide, we worked with countless students, staff, and faculty to implement the 2020 rules in a way that would allow us to come into compliance and work to stay in alignment whenever feasible with best practices and our values and commitments. We approached this work through a two-phase plan. Phase 1 brought us into compliance by August 14th and included the implementation of an Executive Order 70, which is titled Compliance with the Education Department Sexual Harassment Regulations. We had to write emergency rules for the Washington Administrative Code, where the Student Conduct Code lives. We adjusted various roles, functions, and procedures across the university, and we updated multiple documents, including our Know Your Rights and Resources Guide, our STOP brochure, our Title IX website, created a faculty and staff page, FAQs, etc. Now we're in phase 2, which is where we are at the moment and will continue at least through June 21 and perhaps beyond. What we'll be doing during this phase 2 period is first monitoring court rulings and political changes. Next week's election will have an impact on these rules and could, depending on the outcome, lead to yet another federal rulemaking process. We'll also be assessing, evaluating, and adjusting everything that we did in phase 1, like the solutions that we implemented to come into compliance. We'll be working with work teams, outreaching to other colleges and universities, and hosting listening sessions with you, our stakeholders. And finally, we will need to finalize our emergency and interim policy and code implementations in a more integrated way into our systems. So let me just do a quick overview about what the 2020 regulations actually changed. So first, they created a new category of employee, an official required to report. In the federal rules, this is called an official with authority. We'll talk about that in a moment. They also put regulatory language around supportive measures. The University of Washington's always offered supportive measures, but now the regulations require that we do so, and they also require that we keep records about how we do that. They define what a formal complaint is, and we'll spend quite a bit of time talking about that in a moment. And I think what a lot of folks are aware of is that the federal definitions of prohibited conduct are new and different. And when conduct meets those definitions, there's a very prescribed federal grievance process that we need to follow. And then the last thing that we'll highlight is that these federal regulations apply to employees and students. And I think not everyone was expecting that. So that was an interesting twist when we had 100 days to come into compliance. So before we get into the specifics about what changed, let me underscore what did not change. If you or someone you know has experienced sexual harassment, sexual assault, or other sexual misconduct, you can still access a confidential advocate, safe campus, or counseling and support services, and you can still make a choice to submit a formal complaint or not. I want to underscore that
Valerie, you're muted somehow.
Okay. Should I start over on this particular slide?
You got muted right after you said, I want to underscore.
Okay, great, thank you. So what I was saying is that confidential advocates are a good place to start for students, staff, or faculty members, but not only expert in the resources and options, they have legally protected confidentiality. Advocates can help develop an individualized plan, explain all reporting options, attend meetings, and explore and help implement supportive measures, which we'll talk about more shortly. One change I will note is that now all formal complaints must come to the University Complaint Investigation Resolution Office, the office we refer to as UCERO, or to the Title IX Investigation Office. Human Resources is no longer an intake office for requests for investigation related to sexual harassment, but you can go to HR folks for support. And if you want to submit a formal complaint, they'll direct you to UCERO. Another thing that has not changed is the rule of safe campus. The new regulations eliminated the responsible employee requirement that some of you were aware of from your work at other institutions. But at UW, we did not have a policy that required employees to report. Instead, we encourage all employees to get support and reporting options to a person who has experienced harm by calling Safe Campus. We refer to this as the Title IX protocol, which is shown here on this slide. When a student or employee contacts Safe Campus about sexual misconduct, their staff does 4 things. They conduct a real-time safety assessment to see if there's any imminent worries or need to address harm. They provide a rights and resources guide with options for reporting, including how to submit a formal complaint. They connect folks to a confidential advocate who then reaches out directly. And then Safe Campus shares the information with my office so that we can assess for safety and patterns at the institution. Anyone who calls Safe Campus can do so anonymously, and you do not have to share the identity of the person who's experienced harm. This is important because we want to have that option in place to give agency over if or when they want others to know about what they've experienced, and if or when they want any action taken, formal or informal. I've mentioned that the 2020 federal rules eliminated the responsible employee language and has been replaced with a requirement that universities take action when the university has actual knowledge of possible sexual misconduct. Per the new regulations, actual knowledge exists when the Title IX coordinator or an official with authority is aware of possible sexual misconduct. The federal rules did not define official with authority, so each school had to do that for themselves. What the rules do specify is that when the university has actual knowledge, that is when an official required to report is aware of potential sexual misconduct, the university is obligated to first offer and facilitate supportive measures, second, explain how to make a formal complaint, and third, document that we've done those 2 things. One positive outcome from these rules is that the required response is not an immediate investigation, which may not be what the focus of the misconduct is seeking. It is instead to offer support and to ensure that the person who has been harmed is aware of their right to submit a formal complaint and request an investigation. At UW, we have defined official with authority or officials required to report in 3 possible buckets. First, those who report directly to the president or provost. I think you know who you are. Second, those of you with the authority to impose a full range of corrective action, including termination or dismissal. If you do not have the authority to dismiss someone from their job without higher level approval, you don't fall into this category. And then third, there's a category of otherwise designated by the Vice President of Human Resources, the Vice Provost of Academic Personnel, or Compliance Services. And folks in this third bucket are largely human resource consultants, folks in academic personnel or academic HR, and student conduct officers. This is an intentionally narrow band of individuals, which is in alignment with best practices of not perpetuating further harm with policies that take agency and choice away from a survivor. For folks who've been designated officials required to report, you have one singular obligation. Rather than being encouraged to contact Safe Campus or the Title IX coordinator, you are required to do so. And when you do so, you must share the details you have, including names. Safe Campus makes their outreach as usual when you reach out to Safe Campus, and the Title IX protocol we discussed a moment ago falls into place. And then my office facilitates any follow-up and record keeping. UW's officials required to report received notice of their designation in August, and the list of who is an official required to report is being updated now to be in alignment with new delegations of authority, and it will be posted in early November. In the meantime, I can tell you it includes a few hundred folks combined on all 3 campuses and no faculty except those who are also deans or who have another executive leadership appointment. For example, at UW-Bothell, there are approximately 15 folks who've been identified as officials required to report. They include the chancellor, 2 vice chancellors, the deans, and student conduct staff. We'll be organizing an open process in the winter quarter to assess how we have implemented this requirement for officials with authority. And of course, we welcome your comments and questions today during the Q&A as well. Next, we'll talk about supportive measures.
As Valerie said, the regulations require that any time the university has actual knowledge that an individual may have experienced sexual harassment or sexual misconduct, the individual will be offered with supportive measures and receive an explanation of how to file a formal complaint. Supportive measures are non-disciplinary, non-punitive, individualized services or adjustments offered to complainants and respondents that are designed either to restore or provide equal access to a program or activity, whether academic or employment related at the university. At the University of Washington, confidential advocates have always been and remain the individuals who can provide confidential support and facilitate the implementation of many supportive measures. When confidential advocates receive a referral from Safe Campus, the Office of the Title IX Coordinator, or an investigating office, advocates will reach out to the individual who experienced the alleged harassment or violence and share options for supportive measures and inform that individual how to make a formal complaint. When someone is referred to an advocate through Safe Campus or the Office of the Title IX Coordinator, advocates must document supportive measures. If someone directly seeks assistance from an advocate, those same record-keeping provisions do not apply because the university does not have actual knowledge. To implement supportive measures, staff at the university may need to work together. For example, advocates may need to contact the Office of the Title IX Coordinator, Safe Campus, professors, human resources, investigators, and supervisors for assistance. Likewise, the university's respondent resources or human resource consultants may implement supportive measures for student or employee respondents. No contact directives are one example of supportive measures. Such directives will often be mutual in nature as the federal Title IX regulations change the analysis that determines when and how a one-way no contact directive could be appropriate. An individual may also seek a no contact directive even if they do not wish to make a formal complaint. We recommend consulting with an advocate or the Office of the Title IX Coordinator if someone is interested in this option. The new federal regulations are very clear about the differences between a report and a formal complaint. A report is basically a disclosure or observation either to a Title IX official required to report or via a call to Safe Campus or the Office of the Title IX Coordinator that includes sufficient information to offer support and refer to an advocate. When the university receives a report, supportive measures will be offered to the individual who experienced the alleged harassment or violence, as I explained previously. A formal complaint, on the other hand, is a written request from a complainant or the Title IX coordinator seeking a university investigation. Anyone who wants a university investigation must submit a formal complaint, and that complaint must be made to either USERO or the Title IX Investigation Office. A formal complaint does two things. It alleges sexual harassment and it requests a university investigation. Once a formal complaint is submitted, USERO and the Title IX Investigation Office investigators will determine whether the alleged conduct meets the federal definition and jurisdictional criteria, which I'll cover in a bit, the university policy definition, or both definitions. This will determine what pathway an investigation will follow.
So to summarize, a report results in the offer of support and an explanation of how to make a formal complaint, and an assessment as well by the Title IX coordinator if there are broader safety issues that need to be addressed. Reports are generally made to an official required to report, which includes the Title IX coordinator, or via a direct call to Safe Campus. Supportive measures are available to everyone, whether or not a formal complaint is submitted, and a formal complaint is a request from the complainant themselves or the Title IX coordinator for a university investigation. Complaints must be submitted, like I said before, about what happens when a formal complaint is made. And we just want to underscore that there's now two pathways for the investigation and adjudication to follow.
So now I will cover what sexual misconduct the federal Title IX regulations prohibit. These definitions determine when the federal regulations pathway must be used. The federal regulations specifically prohibit quid pro quo sexual harassment that occurs by an employee. Hostile environment sexual harassment, which is defined as unwelcome conduct on the basis of sex that is so severe, pervasive, and objectively offensive that it effectively denies equal access to a complainant's academic or workplace environment. And sexual assault, dating violence, domestic violence, and stalking, as defined by either the Clery Act or the Violence Against Women Act. University of Washington policy covers additional forms of sexual harassment and sexual violence. UW continues to prohibit additional forms of behavior because our community values all of its students and employees, and because our commitment to gender equity does not stop at what the federal government has deemed as sufficient. We know that our students and employees can be impacted in more numerous ways and can suffer harm based on a greater range of behaviors than Betsy DeVos and the Department of Education wish to acknowledge. Some additional prohibited conduct in the University of Washington policies include quid pro quo sexual harassment that involves conduct or requests made by a student. Our definition of hostile environment sexual harassment is broader, as the unwelcome sexual conduct must be sufficiently severe, persistent, or pervasive. The difference between the "and" in the federal regulations definition and the "or" in the University of Washington definition is significant. University of Washington policy also prohibits a broader range of sexual assault, in addition to prohibiting sexual exploitation and additional types of sexual violence. The federal regulations also have what we call jurisdictional criteria. The new regulations apply when the conduct occurred in the United States, the conduct occurred in connection with a university program or activity. This is easy to assess if the alleged conduct occurred in a classroom or on-campus workplace or during an off-campus event that's sponsored by a registered student organization or a staff organization, or during a conference, training, or other event which the university sent its students to or employees to. For example, academic conferences in the United States would satisfy this criteria. In addition, the regulations apply to conduct that occurs on property owned by registered student organizations, which at the University of Washington translates to fraternities and sororities. In addition, the complainant must be a student, employee, applicant, or someone participating in or attempting to participate in university activities. If all of these criteria are met, and the alleged conduct is prohibited conduct as defined by the federal regulations, then the process prescribed by the federal regulations applies. University of Washington policies will continue to apply more broadly and in a greater range of situations. This is because we want to continue protecting members of our community from harassment that occurs while our students are studying abroad or while our employees are working abroad. We don't want students who experienced harm in an off-campus apartment to have no pathway by which the university may investigate the alleged behavior. Because of this, the University of Washington will maintain greater jurisdiction using its own policies. So this brings us to the different pathways through which an investigation may occur. We'll use the prescribed federal process when we're mandated to do so based on the definitions and criteria I just discussed. Alternatively, when the federal rules do not apply, we'll employ the processes that we've used for years on the employee side and the process that's been in place since the 2017 revision of the Student Conduct Code for students. As Valerie indicated, USERO and the Title IX Investigation Office investigators will assess each complaint to determine whether or not the federal regulations apply. If the federal regulations do not apply to the alleged conduct, the University of Washington may still investigate using other parts of the Student Conduct Code or other university policies that apply to employees, for example, Executive Order 31. The federal regulations impose specific investigation requirements upon investigators, and many of these do not differ from the University of Washington's current practices. Investigators must provide notice of an investigation to the parties, and we have been providing such notice to the parties for years. The notice must include basic information, such as the names of the parties, information about where and when the alleged conduct occurred, and information about the facts of what's being alleged. In addition to these requirements, the notice will describe the non-retaliation policy and other required details. The investigation will proceed as the University of Washington investigators always have, with investigators interviewing parties and witnesses and gathering potentially relevant documents. Investigators will analyze and assess the evidence that the investigation yields. Under the federal regulations, and this is a change from current University of Washington practices, the parties will receive an opportunity to review the evidence that was gathered during the investigation. The parties may share their perspective with the investigator about what they think is most relevant. Where the federal regulation process is at play, a hearing with live, verbally conducted cross-examination must occur. In matters where the federal regulations do not apply, the previous process for students, staff, and faculty will be used. In some student matters, but not all, the process already involves a hearing. When only violations of University of Washington policy have been alleged, cross-examination will continue with parties submitting written questions in real time, which the hearing officer asks. This has been the university's practice since 2017. The federal regulations require that the hearing include cross-examination that is live, direct, and conducted verbally by party advisors. The regulations require cross-examination because the Department of Education believes that cross-examination is the best tool to determine the truth about what happened. The Department of Education has also established regulations about what and how evidence might be considered. The federal regulations hearing requirement is a change from the University of Washington's current practices, where student hearings occur only when or if a sanction of dismissal or suspension are possible, and employees hearings only occur for faculty and other academic personnel in limited circumstances. One area in which the federal regulations provided the University of Washington a choice was with respect to what evidentiary standard it uses. The University of Washington will be continuing to use the preponderance of evidence standard, which is what it has used for both student and employee investigations for years. Preponderance of the evidence means that an individual may not be held responsible for allegations of misconduct unless the decision maker concludes, based on all of the evidence in the record, that it is more likely than not that the respondent engaged in an act or acts of misconduct. This is seen as the more equitable standard as it provides complainants and respondents equal stake in the outcome. Both the complainant and respondent have an equal opportunity of providing evidence that supports their position. This standard is recognized as the best standard for cases involving individual civil rights and is, in fact, what civil courts use for these types of cases. In applying the most equitable standard, the university and its investigators begin investigations with two presumptions. The first is that the respondent is not responsible for engaging in the alleged conduct unless and until evidence supports the finding that the alleged misconduct occurred. The second presumption is that a complainant brought forth the allegations in good faith. In other words, the complainant believes the truth of what they've alleged and has not brought forth allegations for reasons other than to address how it is that they've been harmed. The federal rules require significant changes for employees. I will outline some of the primary differences between what the regulations require and what the University of Washington has typically done. When conduct prohibited by the federal regulations is alleged, employees may review evidence gathered by the investigator before an investigative report is finalized. For employees, too, the requirement of a written report summarizing evidence is a change. Unlike in cases involving students, a report for employees was only written in limited circumstances. The requirement of a live hearing for every case involving allegations of the conduct the federal regulations prohibit is also a significant change, as hearings only occurred in limited circumstances where faculty and academic personnel codes required such a hearing. Decisions about whether or not an employee is found responsible for allegations of the conduct the federal regulations prohibit will be made by a hearing officer or panel of decision makers. And these are the same decision makers who will decide the appropriate sanction if a violation is found. Who makes these decisions depends upon what type of employee, for example, classified staff, faculty, professional staff, academic personnel, the respondent is. This is because there are separate codes for different types of employees. It's also a change for employees to be able to appeal the university's decision. Complainants will now have specific rights in investigations and adjudications following faculty and other involving faculty and other academic personnel. Typically, the codes governing these proceedings provided rights for the individual accused, but not for the complainant. As a reminder, since the University of Washington will continue to have two pathways for investigations, this means that if an employee is not alleged to have engaged in conduct prohibited by the federal regulations, but University of Washington policy violations are instead the only ones in question, investigators may still make decisions about whether the University of Washington policies were violated, and departments will determine appropriate sanctions.
So where do we go from here? We will be keeping a close eye on the lawsuits that have been filed opposing these new regulations, and of course the outcome of the election next week, like I've mentioned. Either way, we need to finalize our interim policies and code, and we'll be using established processes to do so. For the student conduct code, revision timelines will require us to finalize the current emergency rules by December for implementation in April. With that in mind, we will be gathering our community together again, starting in January, to move into phase 2 revision of the code that will either incorporate our emergency rules more seamlessly or revamp them entirely. And in addition to these actions, we'll be assessing what we've put in place during phase 1. For example, like I mentioned before, we'll be reviewing this officials required to report requirement and how we've implemented that. We'll also be looking at how we offer and track supportive measures, who serves as an advisor in a hearing, and how to best integrate the federal requirements with our medical centers, our faculty code, and the Robinson Center Transition School. We will also continue in our commitments to move beyond compliance. To that end, I want to talk briefly about our Title IX Education and Prevention Initiative. This initiative is a result of recommendations provided to the Title IX Steering Committee and will result in education on these issues for everyone in our community. Because we're such a large institution, there will be introductory training rolled out in an online format, which will then be expanded upon in in-person sessions. Most importantly, the learning outcomes for this training are primarily related to the prevention of harm. A tri-campus committee of staff, faculty, and students has been working to develop a curriculum that is tailored to UW, that lays the foundation for additional education and prevention work, and that aims to change behavior, not just provide compliance-focused information. Numerous stakeholder groups have been conducted in recent months, and over 1,300 responses were provided in an online survey seeking input to the curriculum. The rollout of this content will begin later this academic year and will start with new employees first, then new students. You can see on this slide the topics that will be included, with content organized into 3 sections. Primary prevention is a focus on preventing harm before it happens through behavior and norms change. Secondary prevention includes strategies such as bystander intervention to mitigate the effects of harm in the moment, And tertiary prevention is essentially responding after harm has already occurred. The approach to this training is based on the belief that a focus on primary prevention is what will truly change our culture to one free of violence and harm.
Valerie talked about some of our work in the prevention space, and I want to introduce a topic in the response space. There are many instances where a formal adjudicative process may not be what everyone wants. In some ways, it resembles the criminal justice system. It seeks to punish someone when wrongdoing is found. It relies on evidence, which could be limited. It focuses on whether a policy has been violated. It focuses on an alleged perpetrator of harm, the person we call the respondent. Even when a respondent is found responsible, it's unlikely the process has been healing for the survivor. The adjudicative process does not address harms to a community whose members include both the respondent and the complainant. For all of these reasons, we are interested in exploring the possibilities of alternative resolution methods, which include restorative justice. Many folks at the university in various pockets are already exploring how and whether the university could adopt alternative resolution paths. Alternative resolutions often have different goals than adjudicative processes. Instead of a decision finding someone accountable for a policy violation, an individual or individuals may voluntarily agree to take action to repair harms to other individuals or to their community. Healing rather than exacerbating trauma is a goal, as is reconciling interpersonal conflict, and reintegrating rather than marginalizing individuals who are members of our community. Based on what I've shared about alternative resolutions, it's probably apparent that an alternative resolution process would not be appropriate or desirable in every situation. In fact, in many situations, an alternative process may be the last thing a person who has already been harmed wants. The university would never impose an alternative process, and even when an individual or individuals are interested in one, it needs to be determined whether such a resolution would even be appropriate. This assessment involves ensuring that any alternative process is voluntary on the behalf of both parties. Further, unless a respondent is willing to admit freely that their actions caused harm, no alternative process is appropriate. I want to underscore that an alternative resolution takes significant preparation on the parts of those involved. A facilitator ensures that interactions are structured and do not cause additional harm. The facilitator also helps ensure that at the end of the process, remedies have been explored and agreed to by all those who are involved. These remedies could be workshops, courses about violence, a permanent no contact directive, or community service. These are also outcomes that could come at the end of an adjudicative process, but the difference is that in alternative resolution, the parties select and agree to these themselves. They are not imposed by the university. The University of Washington Office of the Ombud is already available and working with hundreds of folks each year to assist with conflicts or concerns of all kinds. We are looking forward to participating in broader conversation with the ombuds and with others across the university to consider the work the Office of the Ombud already does and how or if that might be expanded to include restorative justice in cases of sexual harassment or other sexual misconduct. Then, beyond complying with laws, we also believe our community is entitled to transparency about what is happening on campus insofar as it relates to sexual misconduct reports, investigations, and outcomes. Earlier this year, the Office of the Title IX Coordinator committed to compiling an annual report for the 2019-2020 fiscal year. Unfortunately, with the pandemic and the federal Title IX regulations, this report has been delayed. We still plan to complete it and have started to gather information and data from the offices and individuals who maintain it throughout the 3 campuses. Our plan is for the first report to focus on data specific to students, and subsequent reports will be expanded to include data specific to employees. The final initiative I'll mention is our desire to facilitate user-focused input on our website and other materials. We have made a lot of changes and additions to our website, but if that information is not accessible or it isn't clear to our community, then it also is not helpful or transparent.
So we've covered a lot of information today, from our values and commitment to institutional courage to the specific changes and procedures required by the 2020 federal regulations, to initiatives and approaches that go beyond compliance to prevention, restoration, and transparency. We welcome your questions and comments today and look forward to working with you in smaller groups and conversations in coming weeks and months. I'll turn it back to Glenna now for questions and comments that have been directed to her in the Zoom chat.
Thanks so much, Valerie and Megs. I'm going to start with some questions, and folks, please go ahead and send questions either directly to me, or it looks like some questions have gone to everyone. That's fine too. Do officials with authority to report or responsibility to report let students know that they are required to report prior to the disclosure? Let's say if the official is kind of feeling as though the student's about to make a disclosure.
I can go ahead and take that one. That's certainly the best practice, and we have, I think we're in the process of really refining what kind of guidance and training we can give to folks. We have asked that they do that, and I think what we really like to do is bring people into the fold and make sure that we have the kind of preparation and training so that people have those phrases in a toolbox, kind of mental toolbox that they can utilize quickly. So absolutely acknowledge that's the best practice, and people know that that's what they should do, and we're hoping that that we can continue to reinforce that.
So this question refers to kind of the two pathways. It seems as though by creating two pathways, we invite confusion. Can you talk a little bit about why you didn't just create a single pathway and use the federal regulations definition and process?
I can address that. The reason that we did not do that is because what the federal regulations require is not what we think is the best practice in every situation. We wanted to use, the University of Washington's policies that we had in place for years, we think have taken into account what a lot of the best practices are in different situations. We balance that, what we do in those. We make sure that we provide the required due process, and that we make sure that our process is open so that people feel comfortable reporting. The federal regulations process, we have some concerns, may chill reporting, or may introduce practices that are not necessarily the most fair to both parties. And so for that reason, we've chosen to use the federal process when it is that we're required to do so, and then use the processes that we think are informed by the best practices. That's something that if we learn our community disagrees with over the next several months of conversations, we are open to addressing. But for now, that's the reason that we chose to do the two pathways.
Thank you. This question is regarding the way the regulation applies to employees. So do we use the employee process when the staff is the complainant or the perpetrator, either, both?
I'll take that as well. The employee pathway, so that would be when the respondent is an employee. That is not to say that employees also will not be, employees can be both complainants and respondents, but whether the process that's for students is employed or whether the process for employees is employed really depends upon who the respondent or subject is.
Thank you. If the employee who sexually harassed a number of coworkers is no longer at the UW, but we have been traumatized, can we still have access to Safe Campus?
What was the last part of the question? Can we still have access
to Safe Campus?
Yeah, absolutely. Safe Campus, it takes calls and requests from anyone who reaches out to them. And I think depending upon the services, if folks are still here at the University of Washington, they have a full scope of services available to them. If they are not still at the University of Washington, Safe Campus will take the steps to connect them with community support and services as well.
And this is not part of the question that was asked, but let me also add on, does that apply to the access to advocates? Does that apply to access to CareLink, for instance?
Yeah, for sure. Anybody at the University of Washington, any student has access to our student advocates, any employee has access to our UW-PD victim advocate who helps students and employees. And then if for some reason someone is no longer a member of our community, there are community-based advocates and support services that we can make available to them.
Perfect, thank you. Okay, this is a question about the sexual misconduct disclosure form that's now required to be completed by all incoming UW employees. It's colloquially known as kind of the legislation regarding pass the harasser. Are there guidelines for employment decisions making? Oh, sorry. Are there guidelines for employment decision making when an applicant responds positively to a current or past sexual misconduct investigation?
I can take a run at that, but I might ask Ian if you have anything specific that you would add there. And if you do, you can introduce yourself. No? Okay. All right, so I think the question is, is there a specific pathway in terms of when a disclosure comes in that someone has had previous sexual harassment findings? Is that what the question was?
The question is, if the person who is to be employed answers positively that they have been the subject of current or past sexual misconduct investigation, then is there guidance for what the employer, the UW employer, should do?
Yes, so human resources and our academic personnel folks have been taking the lead in addressing those very questions. It's important to have a thoughtful, intentional process about what we learn when someone discloses what was alleged, what was found, and what was done in terms of follow-up. And so, but I can't speak specifically because I'm not working in their offices, and I would absolutely encourage, there's someone on the phone now or on the call now who wants to add to this. But what I would say is that I do know there's been a lot of thought put into how to do that in an equitable, fair, kind of appropriately thoughtful process.
Thank you. And as a note, I'm running towards the end of the questions that have been submitted, but if you have more questions, please send them. Likely, if you have a question, then other people do too. We have mentioned the presidential elections in a couple of different places in this presentation. What changes in the after the presidential election, one way or the other?
Yeah, I can take a run on that, and then I invite my colleagues to add to it. But I think what has resulted in these 2020 federal rules is a rulemaking process that was undertaken by the current U.S. Department of Education. So if there's a change in the White House in terms of which party is in charge, it's likely that there'll be a change to these rules. There's been commentary from Democratic leaders that they're not in support of these rules in their entirety. So it's possible, I don't know for sure, but it's possible that there would be a process that would be implemented that might be very similar to the process we've just gone through, where there might be some rescinding, some issue of interim guidance, some posting of some new proposed rules, notice and comment period, and then new regulations. All of that takes quite some time, so I wouldn't anticipate any changes immediately, but it's hard to know what to anticipate these days. Things seem to change pretty quickly.
One more question regarding those individuals required to report. Is there a list of those individuals available someplace?
Yes, we have compiled a list. When the folks that we notified in August are part of that list. And what's been happening since then is an update of delegations of authority. You might remember I mentioned kind of 3 buckets of folks that fall into that list. And the folks that have that authority to take a full range of corrective actions has been updated. And so we're in the process of updating that list, and we'll be, once that's done, probably in early November, we'll be able to post that actually publicly and make that available. In the meantime, if anybody wants to check in with my office, we can ask specific questions while we're in the process of updating that list.
And borrowing from a question that we got a couple of times during the summer, does the UW have to comply with federal regulations? And what happens if we weren't to?
I'll answer that.
Take that one next?
Yeah, since Valerie answered the last several, we do have to. What hangs in the balance is federal funding for the university. So that includes any student who receives financial aid from the university. That includes any of the research that is done or supported by federal funding, grants from, so many organizations that are federally based. So if we want our students to continue to be able to access financial aid and our researchers to be able to continue their research, it is necessary that we do comply with these rules.
Thank you. I have come to the end of the questions that have been sent to me. So we can wait a minute or two and see if any other questions come in. Otherwise, we can gift back a few minutes before the noon hour.
And I can, to kind of fill the moment while we're waiting to see if new questions come in, I will point out that we also have with us in this meeting Ian Messerly, who's the manager of the Title IX Investigation Office and the UCRO office. So if folks have specific questions that Ian might be able to address, I know he's willing to do that as well.
And in the interest of kind of emphasizing that the Title IX office and the UCRO office and many other offices that are linked together in this Title IX effort are open to additional questions as they come up, please feel free to reach out to the Title IX office. And otherwise, seeing no further questions, thank you very much, everybody.
Thank you. Bye-bye.
Bye-bye.